Starting. All attendees are in listen-only mode.
Good evening and welcome to this webinar tonight, sponsored by Strongbrook. We're excited to be here. My name is Anthony Andel and I'll be your facilitator for this evening's webinar. Appreciate you joining me and taking a couple minutes out of your day to learn a little bit more about estate planning. Disclaimer before we get started today, know that I am not an attorney. I'm not a licensed attorney. We are not giving legal advice during this webinar. This webinar is for educational purposes only, and hope you enjoy the content that we've prepared for you tonight. Tonight we want to really focus on what is an estate plan? Why do you need one? And we're going to cover the next couple of items in the next 40 minutes. Number one, what's included in a comprehensive estate plan? Two, we're going to discuss the 3 common myths about estate planning that really prevent a lot of people from moving forward in implementing and creating their estate plan. We're going to talk about 3 mistakes that most people make in their estate planning. And then ultimately, we're going to end with the number 1 solution that is available to you today for free. I don't want a credit card. We're not going to ask for any credit card information, any type of payment information. Tonight is just about to learn and to take some action at the end if there's an option that feels right for you. I want to get started by discussing the documentation that makes up an estate plan. And there's really kind of 4 main documents that come together to create a cohesive, full, comprehensive estate plan. The first one is your revocable living trust. We'll talk about each of these in just a couple minutes in a little bit greater depth. We're also going to talk about your last will and testament and what does it mean to have a pour-over will. We're going to talk about your powers of attorney and what does it mean to be durable, how do they work, what do they cover, what are their rights. And then we're going to discuss your advanced medical directives. This is also referred to as your living will. So let's get started by talking about what is a revocable living trust. Ultimately, I want you to know that there are 2 types of trusts that exist that you can set up. One is called revocable or living. The other is called irrevocable. So let's discuss what a revocable living trust is first. So when you create your trust, it's like creating a new entity, okay? Just like an LLC, an S corporation, a trust is its own separate entity. The difference is this is not a public record. A trust keeps your estate private. There's no way that anyone would be able to have access to your trust. And that's what we want. One of the benefits of having an estate plan implemented is the privacy that it gives you. One of the things that a lot of people will do is that they will create their paperwork. They've paid for it. They've worked with the attorney or another system, and they have it, and then they think they're done. Well, one of the things that you also have to remember about your trust is that you have to fund assets into the trust. A little bit later tonight, I'm going to discuss how we do that, but it's important to understand that we need to have the assets moved, physically moved into the trust. And that's what gives the ability to avoid probate and some of the other things that are pitfalls to your estate planning. When you create your trust, it's all about control. Without a trust in place, whether you have no estate plan today, whether you have just a will in place, you're leaving the control up to the probate system, which is the courts, where they then have the power to discuss and make decisions regarding your estate. And so by not having revocable living trust, you're giving up that control. The trust then makes it so you determine how and when your assets are passed on to your beneficiaries. So now you can do it on your terms versus a probate judge or the government or how someone else says it should happen. Now, we'll talk in a little bit later about specific assets that we want to move into the trust. But I want to hit on the difference between on what an irrevocable trust is. An irrevocable trust means it cannot be changed or altered once it is created. And the only way to supersede that irrevocable trust is to create a newer trust at a later date and time. Now you might think, why would I want to create an irrevocable trust that cannot be changed or amended while you are alive or of sound mind? The reason is because in some partnership situations, you might come together and say, you know what, we've agreed to certain terms on a deal or a partnership, and we don't want any partner to try and change or cheat the other. And so by creating an irrevocable trust, you're creating an entity that cannot be changed or altered. For most of you, you're probably going to want to have a revocable living trust, which means it can be changed or altered as long as you're 1, over 18 years old, and 2, of sound mind. What that means, as long as you don't have some type of mental disorder like schizophrenia, Alzheimer's, dementia, you're going to be deemed a sound mind, and that way you can change or alter your trust. As you continue on with life, your situations are going to change. You might be in the phase of your life where you're having more kids. You might have a child or a beneficiary pass away. You might decide to change who your trustees are, which is the person that oversees the trust and the distribution of the assets to the beneficiaries. You might decide to add more trustees. You might want to just change it from a revocable to an irrevocable trust, right? So your situation is always evolving. So even once you get this in place, know that your situation is never fully complete. We want to make sure that we're addressing it and reviewing it from time to time. I'll hit on that a little bit later tonight. Now, let's talk about the last will and testament for a minute. When I look at this document, the first thing that I see people do wrong is they just have a regular will. We recommend that you have, as it's listed on the screen, a pour-over will. Now, what does this mean? A pour-over will simply states, and let's use the example of a checking account at Main Street Bank. And let's just say that you were to pass away and you forgot to transfer that ownership, and what I just mentioned in funding your trust, you forget to fund the trust by moving that checking account in. Well, a pour-over will grandfather certain assets and move them back into the veil of the trust. And so we do want to make sure, if you're taking notes, that look at implementing a pour-over will. That way you do have the benefit, if something was forgotten, that it can be grandfathered in. Now, your will and testament is kind of used in conjunction with your trust. And here's how. Your will states the purpose of your will is to identify who was involved as the beneficiaries of your trust or of your estate plan, and 2, what assets you have. So the will is identifying who and what. The trust then discusses how and when are those assets transferred to the beneficiaries. Within a will, you're going to have an executor, which is the person that oversees what your wishes are. And that's really what the will states, what your wishes are for your estate. The trust is the distributor document, and with the trust you have a trustee. And the purpose of the trustee is to buy, sell, or trade assets or manage assets of the trust until it's time to distribute those to the beneficiaries. Now, this last point at the bottom of this slide is key. Any unfunded assets, if I only have a will or do not have a will, go through probate first. I'll give you an example of this. We have a client here at Strongbrook who, her sister was fortunate enough to win the lottery in a state other than where our client lived. And they elected for the annuity payout, which was like a 25-year payout. And after about 20 years, that person who won the lottery, the sister of our client, had passed away. Well, a lottery winnings can be transferred to a beneficiary. One of the things that the sister had done for our client while she was alive was pay off our client's primary residence with the money that came from the winnings of the lottery. And the sister had done a pretty good job setting up an estate plan, but she did not fund all of the assets into the trust. Specifically, our client's house was left in our client's name, not moved into the trust to be distributed to our client. And what happened upon the death of the sister, the children started looking at the accounting of where monies went and realized that their mother had paid for our client's house. Well, the kids challenged that in court and realized that that house was not inside of the trust. And so our client had to either, one, sell her house because the judge deemed in probate that the kids were entitled to $100,000 of that value of that home. So she either had to sell her house, refinance her house, or pay it out of pocket. Now, fortunately, she did have the funds. She did pay it. But it kind of goes to show you that even when you think everything's complete, and that's the advantage of making sure that we're reviewing your trust every year, is to make sure there is not an asset that you funded that we've automatically left out of the trust, because any unfunded assets will go through the probate process first. Well, let's talk about powers of attorney for a minute. When you look at powers of attorney, there's two main powers of attorney that you have. One that's over your finances and one that's over your health care. Now, I mentioned just a couple minutes ago that within your trust, you're going to have a trustee, and their responsibility is to manage all assets of the trust, to buy and sell and make trades of assets until they distribute to the beneficiaries. Well, the financial power of attorney has zero control over assets inside of the trust. That's the trustee. The power of attorney over your finances is there to represent any assets that are not inside of the trust. Okay? This is an important role because just in that example I used with my client, the financial power of attorney was there to help represent our client and her sister as they went through that process. Okay. Now, they still have the ability to buy assets, sell assets, as long as they're not inside of the trust. But one thing to remember, and the bottom point says this, he or she could even fund assets into your trust prior to the death to avoid probate. So in the event that you were in a car accident and you were incapacitated or you're in a coma, where you're still alive, but you're incapacitated, that financial power of attorney can actually still move assets into the trust prior to death. And if that happens, again, anything that's moved into the trust prior to death avoids probate. So you want to make sure that the person that you choose as your financial power of attorney is someone that you trust, is someone that has good integrity, and ultimately understands what your wishes are for your assets and how they're supposed to be treated as they ultimately work their way to the beneficiaries. The second power of attorney that I want to hit on tonight is for your health care. And this is one that hits close to home for me. Many of you have heard the story of my mother. My mother was in the hospital 32 times the last 35 years of her life. She had cancer 5 times. She was a miraculous woman, strong-willed, very optimistic. But almost 8 years ago, she passed away. Now, at the time of her passing, she did have a living will in place, and I'll talk about that after the power of attorney here to really go through this. But my mother had a living will of what type of care she wanted to receive. The primary power of attorney was my father. Now, he was a long-haul truck driver, and so he was often not at home. We had secondary power of attorneys for my oldest sister first, then myself, and then my little brother. At the time when my mother passed, my little brother was at home. The incident happened. He called 911. My mom was rushed to the hospital. My brother called me and my sister because my dad was in Idaho at the time. We live in Utah. I made it to the hospital first. And by the time I got there, the doctor said, "We've done everything that your mom outlined. She's not coming back. What do you want to do?" And at that point, I was left and faced with a choice. Choice number one was I could keep her on life support until my dad got there to make a decision. 2, I could wait until my sister got there to make a decision. But I knew what my mom wanted and had outlined in her living will. And so when it came to make that decision, I ultimately had to do what the second bullet point says, which is the power of attorney over your healthcare has the ability to terminate life support systems, even if they're not terminally ill. And that's what I did. I chose to end my mother's life because that's what she had stated in her wishes. Now, it's never easy to lose a loved one. And when you go through that mourning and that grieving process, you question a lot of things that happen. But I have a lot of peace to this day because I did what she wanted to do. And so again, as you're looking at the power of attorney over your health care, 1, do they understand what your health care really is? What are your wishes? Do you want to be on life support? Do you not? Do you want to be on pain medication? Do you not? Do you want to be on hospice care? Do you not? So you really need to make sure you're clear on what your wishes are, and 2, understand that they do have the ability to end life. So that is a huge sacred responsibility for these powers of attorney. That ultimately does fit into this last document, your living will and advance directives. And this again just outlines the type of care that you want to receive, the type of medical professionals you want to work with. One of the things that you can also do, we recommend, is turn this document over to the hospitals or the doctors or the teams that you work with for healthcare. A lot of the times, if you've ever been checked in, we just recently had a baby, and as we were checking in the hospital, one of the questions they asked was, do you have a living will? Do you have a directive for your healthcare for your wife and baby if it ever got to that point? So it's good to have these things registered as well, and that's another piece of advice that I would recommend is once you do have your living will in place, register it within the healthcare network that you operate within. So these are the main components that comprise a comprehensive estate plan. Now, as you look at the estate plan, there are a couple myths that we want to kind of bust tonight to show you that there are different ways, and maybe some of these apply to you and maybe they don't. Maybe you've heard of some of these, maybe you haven't. Myth number one is, I just don't have enough assets to justify an estate plan. Whether you're starting out in life, whether you've gone through a bankruptcy, whether you're kind of ending your life, it doesn't matter where you're at. You might have the mentality, I don't have enough. Two, if I have a will, that is enough to protect my assets and my family. And myth number three, setting up an estate plan is too complicated and too expensive. So let's dive into myth number one. I don't have enough assets to justify the need for an estate plan. Well, let's look at a couple things. Most of the people that I've come across in my experience, and doing this over about 9 years, is they just don't know what an estate plan is. They maybe have heard of a will, maybe through TV or family members, but they don't know what it is, how to apply it, how to even get one. Sometimes it's intimidating. You know, if they think, hey, I have to call an attorney, the attorney's in a suit, I'm more of a blue collar type of guy, I don't have time to take off of work to go down to his office. It can be a very intimidating process. When they start asking the questions of, for example, in case of divorce, do you want your trust to be voided or to remain in place for both separated spouses? That's kind of an intimidating question. And so some people just say, it's just too intimidating, I don't even want to go there. There's the cost. I implemented my first estate plan in spring of 2007. And I was 27, my wife was 22, we'd been married for 2 years, didn't have any kids yet, didn't have a whole lot of assets. And I remember we paid our attorney $3,600 for the comprehensive estate plan that I just outlined for you. And I had to finance it with the attorney, and the minimum payment I had to make was $100 a month. I had to put half of it down, and it took a long time for me to pay off that estate plan. Recently, we had another Strongbrook employee who was looking at options for their estate plan. They talked with a different attorney. Theirs came in at $4,700. When you're working with an attorney who has a lot of great education, has a lot of great expertise, you're going to pay for that time to be in front of that individual. And so attorney costs can be very expensive. Sometimes there are uncomfortable topics. You know, which family member are you going to leave your kids to? Sometimes there's disagreements. Sometimes there's strong feelings between both spouses or partners, and you just say, you know what? We don't know what to do. Sometimes you feel it is just complicated. Now, a couple stats. 60 million families are in need of an estate plan in this country right now. When you look at where we're at with the baby boomers, they're in the process of the largest wealth transfer in the history of the world. And as you look at transferring wealth, one of the things that you need to be aware of is the tax implication of these decisions. We really didn't hit on that too much, and we'll probably say that for a different conversation, but the estate tax is 40%. Having a trust in place can help reduce drastically the cost of your estate tax. So these are some of the issues that people are facing as they're looking at their estate plan. From smart money, if you have some assets, maybe just a car and some nice furniture, or minor children, you still need an estate plan, even if taxes are not an issue. And I think this is key. It doesn't matter if you have just a couple of things. You still need to have a trust to keep those things out of probate, of going through the court system, especially for minor children. It's crucial that the caregiver that you've outlined to be the guardian of your children, that your documents actually funnel your kids to that person in the way that you want it to happen. versus having a court that could potentially overrule on what your wishes are. 56% of Americans do not have any estate planning documents in place, and that's even a basic will. So half the country is in that position where they have nothing. Only 23% of American adults over age 50 have a trust. This is crucial because, again, the trust is the document that keeps you out of probate, that actually distributes your assets. Right now, only 23% of Americans over age 50 have a trust. Our goal and mission is to make sure our clients don't fall in line with these statistics. Let's talk about myth number 2. If I have a will, that's enough to protect my assets. Well, I want to let you know right now, as you're listening to this webinar, that whether you have an estate plan in place or not, congratulations, you do have an estate plan. Unfortunately, it's one that's put in place by the government. Now, this isn't a party discussion, but a lot of people feel like our government is very chaotic, very jumbled, and if that's my plan, let me kind of outline what that looks like for you. So with the government's plan, you go through probate, which is the court system. This can be a scary process and a scary ordeal for a lot of people. Now, as you look at probate, what happens is, the reason why you have to go to probate is a judge is issued over your case to act as the distributor of your assets. So again, this is nothing in place, or I only have a will. And the reason being, the will only outlines what your wishes are for your estate. The judge then has to decide what happens. Now, I want to kind of give you an example of what happens in the probate process. My wife has a cousin that lives in California, and a couple of years ago, they went on a trip to Europe, and they were finishing up in Hungary. And their last night in Hungary, it was a father, mother, an older brother, and a younger brother. And as they were traveling back to Budapest that night on a country road, they were hit head-on by a truck. And in that accident, the mother and the oldest brother passed away. They lived in California. And so they didn't have a lot of assets between the two, but they had to go through probate. It took 11 months for their case to be brought before a probate judge. Okay, and so once that happened, then it took another 3 months for the judge to settle that estate. Now, when you talk about the grieving process of losing a family member, whether you knew it was coming or not, it's a heart-wrenching ordeal. To know that then when you go through probate, it takes months for your case to be brought before a judge. Your case now becomes a public record. And so if you're Mr. and Mrs. Client listening to this presentation, and maybe I've worked with you and maybe I haven't, but let's just say that I helped you get a house here at Strongbrook, and I see that you've passed away, I could then say, you know what, Judge, I want to challenge this because I worked with Mr. and Mrs. Client. We had a great relationship, and they told me that if they were to pass away, they wanted me to have the houses that they accumulated. Whether that's right, true or not, the judge then has to take that claim with all seriousness and determine how valid it is. And that's some of the things that go into this probate process. When you implement a trust, it keeps your private matters private, where it's not a public record, and that way it ensures that you are protected to make sure you're distributing your assets the way that you want. The average probate time can take upwards of 12 months. And if you own assets in different states, one of the things we do at Strongbrook is we're buying assets in different states. So we live in Arizona, and Nevada, and Florida, and Tennessee, and Indiana, and wherever you live, if you own an asset in a different state, you also have to go through the probate process in a different state. And then the thousands of dollars of costs. Well, let's kind of break down that for you. You're going to pay filing fees. You're going to pay a personal representative fee, legal notices, bond fees, attorney fees, appraisal fees on assets. The total cost can range anywhere from 1% to 8% of the estate. On a $300,000 estate, that's $3,000 to $24,000, and again, another upwards of 12 months to complete. Now, it's also a law in some states that the person who's representing this can also get reasonable compensation for their time to help you go through this process. So again, why put in all that time, that effort, and that additional cost when you don't need to? That, for us here at Strongbrook, that cost of probate could be enough for a wedding, college tuition, a mission, buying a car, buying a home. And so we don't want to have your estate eroded away by simple little things that are easy to protect. So when you're looking at avoiding probate, we're looking at ways to save money, save time, save the hassle of going through that process, and ultimately protecting your privacy. Now, the other option is you decide, not the courts, what happens. So again, your will states who receives your hard assets. Your trust determines when they're received, at what ages, whether it's a lump sum or whether it's done in phases or distributions. I have a friend who was 18 years old when I was a senior in high school. And his mom had passed away when he was a kid, so it was just him and his dad. He was the only child. And his dad was a great intellectual man, very big on education. My friend got accepted to some great universities across the country. And when it came time for him to go, he actually wanted to do some service work. And that kind of frustrated his dad. The night that my friend got his assignment of where he was going to go do his volunteer work, his dad shot himself in his study. Very tragic situation. But my friend inherited $1.5 million at age 18. He's an adult, had a very basic estate plan in place that just said you get 100% as long as you're 18 or above. So at 18, think what you would have done with $1.5 million. My friend bought a Ferrari, traveled the world, got into drugs and alcohol and women, ultimately didn't go on to his volunteer service work he wanted to do, delayed his education, and in 15 months, 1.25 years, spent $1.5 million. Now today he's cleaned up his life. He's a good member of society, he has a family, he eventually went back to school, got his degree, but every day he regrets his decisions at age 18 because he just didn't know any better. And so one of the things that you get to do with the control is to determine how and when are your assets passed to your beneficiaries. In the event that you have minor children still who are the beneficiaries, the trustee's job is to manage those assets until the time is determined at what age do you start distributions. The other thing that we have there is the guardianship of your children. Don't leave it up to a judge who could decide and put your kids with a different family member, or worse yet, put them into foster care. Make sure that you have control over these important decisions. Myth number 3, setting up a trust, a will, your advance directives, is complicated and too expensive. Well, we make it simple. Now, I'll talk about in a second how we make it simple for you, but let's cover a couple mistakes that people make when they do their estate planning. Number 1 is paying thousands of dollars to an attorney to get these documents in place. When you look at, we'll show you in a second what it costs to put this plan together for you. But you're going to do it for substantially less than what I did mine for back in 2007. Again, $3,600 for that plan. Mistake number 2 is people don't fund the trust once they have the documents in place. So again, you've paid all the money for the paperwork, but now you actually have to move the assets into the trust, deed homes to the trust, move bank accounts, change beneficiary of life insurance policies, change the beneficiaries of your qualified accounts. That's what it means to fund your trust. So again, a lot of people, even a lot of our Strongbrook clients, will get the documents in place, but fail on this simple step of moving documents into the trust. Mistake number 3. They don't have an attorney review on your trust on an annual basis. Remember how I said your estate plan is never officially done. It's always going to come and go. Your life is evolving. Your trust needs to evolve with it. And so for me, when I did my first review, it was a $900 cost to the attorney to sit down for a couple hours, review our trust, review our assets, make sure things were in the right place. And if I'm doing that every year, not only am I paying the cost of setup, the thousands of dollars, but potentially another $1,000 a year just to review my estate plan. It's no wonder that many of you who maybe do have a trust haven't looked at it in 5, 10, 15, 20, 25 years. And that's dangerous because at that point, it's completely outdated from where you're at this point in life. So what's the solution to this? That's why you're here tonight. Strongbrook has put together a comprehensive estate plan. It's internet-based and something that you can be done from the privacy and simplicity of your own home. The process is simple. We've broken down into a number of different steps. One, an easy online platform that you can access anywhere in the world. This process can be completed in as simple as an hour. And if you want to take a little bit longer, have some discussion with your spouse or partner, it can take a little bit longer than that. I've had clients complete this in a day. I've had clients complete it in a couple weeks. Besides just going through the process of actually creating your documents, there's also online education in the form of videos and printed guides that are there to walk you through how to do this. You get constant support through telephone and instant messaging directly to attorneys to ask specific questions in the moment. You have detailed explanations and breakdowns of what it means with some of these questions. Like, what's the difference of irrevocability versus revocability? Remember, irrevocable cannot be changed. Revocable can be changed. And so you have direct help from licensed professional attorneys to answer your questions. You have detailed explanations about your questions. You have video and print guides to help educate you about how to do this. It's simple, it's fast, and again, as long as you have, as it says on the screen, some name and contact info of beneficiaries, names and dates of birth of children, the name and contact info of your trustees and agents, like your power of attorneys, this can be done in as little as an hour. Now, a couple of the things that Strongbrook has helped put in place for our clients, besides just getting the documents, one is a secured document vault that you can store your documents and have access to them anywhere in the world. This would have been extremely helpful for my wife's aunt and uncle when they were in Hungary, going through the situation of losing 2 family members, to have some of those documents that they could access at the touch of a button through a computer. Cloud-based, encrypted, completely secure, never had a breach of security on the system, and you can access those documents 24 hours a day, any day of the year. Another benefit that you get is the online funding kit. And the beautiful thing about this is it's a patent pending system that was created by these attorneys that allows you to actually give instructions on 20 different asset classes to transfer to your trust. Everything from your checking or savings accounts, money markets. This funding kit will actually generate the paperwork necessary to take to the bank and have them actually move your accounts directly into your trust. It gives you instructions how to transfer titles of real estate, other vehicles, property. It talks about how to move life insurance beneficiaries to the trust. It gives you instructions on what to do if you have an entity like an S corporation or an LLC and how to move that into the trust. It even goes all the way down to foreign assets and mineral rights. 20 different asset classes, and gives you instructions on each of how to move these assets to the trust and ultimately fund it, which is then completing your estate plan. Now, when you look at this, the other thing that we want to make sure our clients have access to is ongoing attorney reviews, because again, your situation is going to change. Unlimited support offered by phone and chat features. One of the things that's included in our estate plans is a 10-year of ongoing attorney review at no cost. The ability to make additional changes to your documentation at no cost. And again, something that's stored in a cloud-based storage system for easy access to your plan. Now, the cost of not having one of these plans with Strongbrook is you're paying higher fees to the attorneys, right? The government might actually be in charge of what happens to your assets and your beneficiaries and your heirs and your kids. Your healthcare and financial wishes may be carried out, maybe they won't be. The cost of probate, the cost of time, and that loss of privacy. When you look at what we offer then, an end to the incomplete professional estate plan portfolio through, again, a cloud-based system. It's updated with the current technologies, right? So it's easy to follow this simple plan to execute your plan and make it successful. And now you also replace new practices where everything's kind of going through the internet versus having to go through old practices of taking time off work, traveling down to an attorney, sitting in their office and being intimidated and not understanding fully what you're doing. This peace of mind has a price. The price that our clients can implement an estate plan on is as little as $24.99, $2,500. Again, I'm not asking for a credit card tonight. One of the benefits that we're offering to you because you're listening to this webinar is if you're interested in purchasing this estate plan, whether tonight, over the next couple of weeks, or through the next month, if you do it in the month of October, we will offer a 20% discount off of that price. And so know that we want to make sure that this is as affordable as we can for our clients, so you can actually get these things in place to protect you and your family today. Now, ultimately, though, we want to give you an extra special bonus for participating with us tonight. And I do appreciate your time. I know it's valuable. I know it's a middle day of the week, and there's other things that you could have done with your time. I'm so grateful that you're joining me tonight. Strongbrook's gift to you tonight is we're going to give every one of you a 15-day free trial to test drive this software, to see how it works, to work with our teams, to understand what it means to have this system of getting your will in place, which is also your pour-over will, your revocable trust, your living will for you and your spouse or partner, and power of attorneys for your finances and your health for you and your partner or spouse. And we want you to test it out, show it how it works, ask questions to the attorneys, ask questions to our Strongbrook team. This is how you get this 15-day free trial. Text the word estate to 480-418-1411. It'll then send a follow-up text to say congratulations, and then you just need to put in your first and last name, the state you live in, and your email address, and you'll be set up on that 15-day trial. For those of you that would rather do it through email, the email at the bottom, annemarie.smith@strongbrook.com. Email your first and last name in the state that you reside in, and we will set you up on that 15-day trial. We will then, within the first week, have our team reach out, make sure you have any questions, see if there's anything that we can help you with, and make sure the trial is going well for you. And then we'll have a follow-up at the end of the trial to make sure if you have any additional questions. Again, if you want to then execute this, you have a 20% discount good through the month of October 2015. That does end at midnight on November 1st, October 31st. So thank you for joining us tonight. I hope you've seen value as we discussed some basic principles of estate planning, understanding what this system is all about, understanding how to set up a system that protects you and your family, one where you have complete control over what happens to your estate. I appreciate your time. Thank you very much, and we look forward to speaking with you again.